Welcome to those of you that have joined us. We've just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to those of you that have joined. We've just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start.
Right, I think we should kick off now that we now have a complete panel. There was a moment of complete panic, but now we have a complete panel, which is excellent. Thank you all for joining us. I'm just going to take 1 minute to introduce everyone and then hand over the reins. But I just wanted to explain a little bit of the background to today's webinar. Those of you who've been coming to our events over the years will hopefully have spotted our trend of having one seminar every year, which is a how-to guide, which takes us back to basics and builds up from there on core contentious trusts and estates issues. And today we have a guide to the removal of executors. And it's brought to you by what I've dubbed the Lincoln's Inn Consortium, my own firm of Payne Hicks Beach, from which we have Charlotte Henshall, along with Rose Fetherstonhaugh from XXIV Buildings and Andrew Holden of XXIV Old Buildings. We had very much hoped that we might be able to host you today in the inn and then for some drinks outside on the lawn perhaps, but it wasn't to be, and looking at the weather, I think it's probably just as well. Anyway, I do hope that you will stick around for some dry virtual networking from 5:45 onwards after the webinar. Just a couple of points on house.
How are you using the word dry in that context, Jessica?
Yeah.
Do you mean inside?
Inside and not wet, yeah. but very witty nonetheless, to be clear. Not boring or dull. But boring or dull, sorry, housekeeping points. The webinar is being recorded. So we need to make you aware of that, and also please do raise any questions or comments that occur to you as the webinar proceeds by using the Q&A box. Right, enough from me, over to Charlotte, Rose and Andrew.
Thank you very much. So we have 45 minutes to cover this vast topic of how to remove an executor. So it'll be very much a whistle-stop tour, discussing the key points and finishing off with some hopefully helpful practical tips and takeaways. So to start, there are a number of circumstances, both contentious and non-contentious, in which it may be necessary or appropriate to make an application to court to remove or replace an executor. For example, a conflict of interest may arise between the executor and their own interests, or the persons with primary entitlement to a grant may be unwilling to get on with the administration. I'm sure, as we all know, we must have encountered this. Removing an executor is not always straightforward, and even where the executor agrees to be removed, it's still often necessary to apply to court. So, what is the court's jurisdiction? Unlike their powers in relation to trustees, the courts have no inherent jurisdiction to remove an executor and can only do so under statute. So the first of these provisions, given the court discretion to do this, is section 116 of the Senior Courts Act 1981. This can be used to pass over an executor before a grant has been obtained in order to appoint a personal representative other than the person entitled to take the grant. In the section, it makes clear that it can only be used in special circumstances when it's necessary or expedient to do so. And assessing that, the court will take into account a broad view of what constitutes special circumstances and won't take the decision to pass over lightly. The court has flexibility to make full or limited appointments appointments of personal representatives to deal with the administration of an estate or particular assets in the estate, and is used in a wide variety of circumstances. So examples of where this avenue might be used include where the person entitled to the grant is in prison, making it impossible for him to act, or where there's been undue delay in applying for a grant, or where executors can't be traced or are unwilling to act. And these are all cases where an executor has intermeddled in the estate, so making it impossible for them to simply renounce. So section 116 can't be used once a grant has been obtained. And in this scenario, an application under section 50 of the Administration of Justice Act 1985 is the better provision. So under section 50, this is the most, well, in my experience, commonly used provision when seeking to remove an executor, both in contentious and non-contentious matters. The court has discretion to make an order to replace existing personal representatives with others, or providing there are two or more existing personal representatives, to terminate the appointment of one or more without replacement, ensuring that at least one remains. A section 50 application can be made by or on behalf of the personal representative, for example, if they wish to retire or they wish to remove their co-executor, or by a beneficiary of the estate. Thirdly, and one that I've not actually come across in practice, but I think Rose has, is an application under section 1 of the Judicial Trustees Act 1896.
Niche, really niche.
Very niche. So the court can appoint a judicial trustee to act under the direction of the court. And once appointed, the judicial trustee becomes an officer of the court, and the court supervises the administration of the estate until its conclusion. And in that same application, the existing personal representatives are often removed. But given that, you know, a judicial trustee reports to the court and is more directly under their control, this may be a less attractive appointment than one made under section 50 or section 116. So now turning on to the test that the court applies in an application for removal, I'll hand over to Andrew.
Thanks, Charlotte. So the test that's applied for the removal of executors is the same test that's applied for the removal of trustees. And the case that's always referred to in this context is Privy Council decision called Letterstedt and Brewers. So much so, one is writing a letter of claim in relation to a removal application. It's often referred to as a Letterstedt and Brewers letter for some reason. So what's Letterstedt and Brewers all about? Well, here it is, Privy Council decision from way back when. And it's quite interesting for what it says and what it doesn't say, I suppose. It's a case from South Africa, all about some problems in the administration of the estate of a chap called Letterstedt. And regrettably, he died and his daughter inherited his estate, which included some working mine in South Africa. And it was being run by a board of executors from Cape Town. But they did a bad job of making money off of this mine. So she took them to court in South Africa and sought an account. And they gave an account. And so those proceedings were settled. And then she wasn't happy. So then she brought further proceedings against them. And in those proceedings, she asked for the board, which represented the executors of old man Letterstedt's estate, to be removed. And the court below disagreed, but the Privy Council reversed that decision and decided that the executors should be removed from office. Now, in this context, there are three bits of the judgment of Lord Blackburn, who gives the judgment of the court, which are always referred to in the context of executor and trustee removal applications. And they are to a certain extent inconsistent with one another. So bear with me, I'll just give them to you and you can make of them what you will. So Lord Blackburn starts his judgment by talking about all of the bad things that these executors have been up to. And then he refers to an old textbook called Story on Equity Jurisprudence, which says, in cases of positive misconduct, courts of equity have no difficulty in interposing to remove trustees who have abused their trust. It is not indeed every mistake or neglect of duty or inaccuracy or conduct of trustees which will induce courts of equity to adopt such a course, but the acts must be such as to endanger the trust property or to show a want of honesty or a want of proper capacity to execute the duties or a want of reasonable fidelity. So you don't just have to be bad, you have to show a lack of honesty or that you've put the trust property in danger before you're removed. However, his lordship went on, and this is the second bit that's referred to. The reason why there is so little to be found in the books on this subject is probably that suggested by Mr. Davy in his argument. As soon as all questions of character are as far settled as the nature of the case admits, if it appears clear that the continuance of the trustee would be detrimental to the execution of the trusts, even if for no other reason than that human infirmity would prevent those beneficially interested or those who act for them from working in harmony with the trustee, and if there's no reason to the contrary from the intentions of the framer of the trust to give this trustee a benefit or otherwise, the trustee is always advised by his counsel to resign and does so. I'm sure you'll reflect on the accuracy of those words in the modern context. If without any reasonable ground he refused to do so, it seems to their lordships that the court might think it proper to remove him. But cases involving the necessity of deciding this, if they ever arise, do so without getting reported, apparently. If for no other reason human infirmity stops them from working together, that's the reason for removal. And then passage number 3, it is quite true that friction or hostility between trustees and the immediate possessor of the trust estate, i.e. the beneficiaries, is not of itself a reason for the removal of the trustees, but where the hostility is grounded on the mode in which the trust has been administered, where it has been caused wholly or partially by substantial overcharges against the trust estate, it is certainly not to be disregarded. So 3 sections of the judgment which are always quoted in this context, but they really do point in different directions. The first points towards a high threshold of misconduct being needed for the removal of trustees. The others suggest that a breakdown in the relationship may be sufficient, albeit mere friction and hostility is not enough, we are told. So from that, we are left to construct the test for the removal of executors or trustees. Just before I hand over to Rose, I would point out that the actual finding of fact in Letterstedt and Brewers was actually quite bad for the executors. So Lord Blackburn looked through some of their estate accounts, and he said that one of the accounts was, quote, extravagant. Their lordships couldn't understand it, even with all the assistance given by counsel. And then he makes a finding that even though there wasn't concealment or good faith, the making of such charges can only be made by persons who are themselves exasperated by the course pursued towards them and are determined to try somehow or other to get remuneration of which they conceive themselves to have been unjustly deprived. So in other words, charging money they weren't entitled to because they thought they hadn't been paid enough, which doesn't sound odd.
That is quite naughty, yeah.
So actually, there's a finding of quite serious misconduct in the Letterstedt case itself. But those are the makings of a test, Rose, for removal. But what do you make of some of the specific aspects of the test? So hostility grounded on the mode in which the trust has been administered. But what about if removal is sought right at the end of the administration of the trust? Does that make any difference?
So I think, could we have the next slide, please, Joe? Yeah, so that's an interesting practical point, if I may say so, Andrew. And firstly, can I just say I really like that you brought Letterstead as a prop. I think that's quite important and very good. But yes, does the status of the administration make a difference? I think this is obviously something of quite practical application, because the administration of the estate, if you're making an application for removal at the beginning, then you might have quite different considerations where none of the estate assets have been sold, if the estate assets are not liquid and so on, or if you've got to the end of a particularly frustrating administration where perhaps you've got concerns about what's happened, but everything has largely been wound up. And I think this is something that plays very much into costs, because costs are a very important element of executor removal applications. The court will be concerned to know, is it going to cost an enormous amount of money to replace the existing executors, and is it worth it? Sort of a cost benefit analysis. And I think that that's a question that will have increasing practical relevance the further you get into an administration, because the less there is for the new administrator to do, but the more reading in they have to do because they don't have any experience of what's happened so far. I think that will be quite important in terms of how the court will weigh that up, the benefit to the trust. But I do think that it's important not to fixate on this point, although undoubtedly it will have relevance, because there was quite an interesting discussion of this in Rodman and Long, where the executor had said, well, but everything's all done and tied up. There are only a few loose ends, and so it's just pointless to remove me. And this again was a Chief Master decision. He's come out with quite a few of them recently. He said that, well, the test isn't, is there anything left to do? It's what is in the interests of the beneficiaries as a whole. And if that's removal, then so be it, looking at that cost benefit analysis. And I think something that is also quite interesting to think about in this context is, are there any accrued breach of trust or devastabit claims? Because quite often, you know, it might look like the estate's nearly been wound up, but if there are allegations that the executors have caused loss to the trust, then those will be, to the extent that those are claims with any value to them, those will be assets of the estate that are probably are by their nature unadministered. So it might turn out that there is quite a lot for the new administrator to do, and that can't be done by the existing executors because they've committed the breach of duty themselves. What do you think about that, Andrew?
Yeah, certainly if you have a set of claims that the estate might bring against the executors, then by definition, the estate hasn't been fully administered. Yeah. So I think that's quite a nice way out of the idea there's not much left for the executors to do. But what about the other point that we were going to touch on, which is, I think sort of comes from the second dicta from Letterstedt, which is, if there's no reason to the contrary from the intentions of the framer of the trust for removal. So what difference does it make if these are the people who have been chosen by the testator to administer the estate? Because I know that's sometimes referred to as a relevant factor, although it's difficult to see why.
For sure. Although it's difficult to see why, you're sort of giving away your view on that there, Andrew. Can we have the next slide, please, Joe? Thank you. Yes, so it's something that often comes up in executor removals, particularly from lay executors, I always think, is the fact that the testator or testatrix chose them to be the executor. So they say, well, mum chose me and she didn't choose you, usually the siblings. So, you know, that's material and means I shouldn't be removed. But how relevant or important really is that? There are a couple of cases we can mention here. The first one is a case called Alkin and Raymond from a few years ago, which actually cited an Australian decision called Monty and Delmo, which is a bit of a strange name, but there we go, in which the judge said the testator's selection of executor should not be lightly set aside. It should not be disregarded, except at the least for serious reason, which is quite a strong statement, really. But if you go on to read to the end of Alkin and Raymond, the judge clearly did think that there was serious reason, because he went on to remove both executors. And then looking again at Kershaw and Micklethwaite, that's another one where choice comes up. In this one, the judge is a bit more wishy-washy. He says the choice of executors is capable of being of relevance, but if only because the testator might have been expected to have knowledge of the characters involved, which is, it's not quite as strongly put. And in this case, unlike in Alkin and Raymond, the executors weren't removed, and the judge did say that the fact that the testatrix chose the defendants to be her executors militated against their removal. And importantly, he said that there was actually quite cogent evidence that she'd given quite a lot of thought to who her executors should be in this context. But I think it's interesting, when you actually look at the judgment, he had already decided that there was no good reason proposed by the claimant for any of the defendants to be removed. So he'd said, I don't think they should be removed. And then he'd gone on to list some further positive reasons why they should stay. One of which was the fact that the executrix the testatrix had chosen them. And there had also been this positive evidence, which I think is quite unusual in executor removal claims, because you won't usually have disclosure of the will file in the executor removal claim. So you might have nothing more than the fact that they're named in the will as having been chosen. So on balance, drawing that all together, I think it is capable of being relevant, and I would say of more or less relevance, depending on how much thought they actually put into it. And I think perhaps looking at it at another way is, did they make a good choice? Because if they made a good choice and, you know, they're a very appropriate person, a partner in a law firm with specialist expertise in whatever the assets of the estate are, then you can see that that is of relevance, but less because they've chosen them than because they're just a competent person. But I would say that it won't usually, if ever, be a deciding factor when there are obviously good reasons for them to stay or to go. I don't think if you've got somebody who's committed horrendous breaches of trust or duty, that the fact that they've been chosen will make any difference.
Yeah, I tend to agree with that. And I mean, the test case would be if there are clear grounds for removal. It's difficult to see why the fact that the testator chose these people would change the outcome in those circumstances.
Yeah, exactly.
But if we then look at, if we go back to the first bit of dictum that I cited from Letterstedt from Story's equity jurisprudence, that tells us that not every mistake or neglect of duty suffices to remove an executor. The acts of omissions must be such as to endanger the trust property or show a want of honesty or a want of proper capacity or a want of reasonable fidelity. So presumably, Rose, that means that if a trustee or executor is to be removed on the grounds of misconduct, one would have to go to trial and prove misconduct to meet that test from the Privy Council, wouldn't one?
Well, would one or wouldn't one? This is where I think we get into looking at a case from a more recent perspective, at the other end of the telescope. You get Chief Master Marsh's commentary in Schumacher and Clark. And this actually wasn't a substantive decision. It wasn't a decision about whether somebody should be removed or not. It was actually a judgment on two procedural issues. So whether the claim should be tried by a judge and whether there should be cross-examination, because one of the parties was saying, well, there have been allegations of bad faith and these should be tested. And so this led Chief Master Marsh to go off on one, in the politest possible way, obviously, about what he thought the jurisdiction involved. And his view is that the jurisdiction of removal is actually a pretty straightforward one. And he says, well, okay, there's not really any clue in Section 50 itself about how the jurisdiction should be exercised. But in my view, and looking at the authorities and so on, the core concern of the court is what is in the best interest of the beneficiaries, looking at their interests in the round. And he says that actually this isn't dependent on adverse findings of fact. It's not usual civil litigation where you'd have one side's case being proved right or wrong. He says, in fact, the court shouldn't make adverse findings, because that might unfairly prejudge a potential breach of trust claim to come in the future. And in fact, he says that it will usually suffice for the court to conclude that there's a good arguable case, albeit he then caveats it a bit by saying, well, you can't just say there's been some falling out or that something's not good enough. But he does then say that if the PR doesn't give a satisfactory response, the court is likely to exercise its powers without determining disputed issues of fact. And he goes on to say that the claim's not just about the executors and the beneficiaries, it's about the estate or the trust seen separately from them. And I know that's something that seems a bit odd, because obviously the trust in itself it's not an entity by itself, a separate entity. But I think what he must mean is you're looking at the beneficiaries as a class and seeing what's in their interests. And if there's a good arguable case for removal, looking at the allegations that have been made, then that will usually be good enough. Do you think that that's taking it too far?
Well, as you say, he's delivered 2 judgments recently, Long and Rodman, and then Schumacher and Clark. And it does develop the jurisdiction in the procedural aspect in a way that is interesting and potentially quite a bit troubling, certainly if you're for the executor. Yeah. I don't know what, certainly the bit of his judgment in Schumacher and Clark where he says that one needs to look at the trust as an entity divorced from the trustees and the beneficiaries is a bit of heresy that you've tried to explain. I'm certainly a better attempt at explaining it than I could achieve, but put that to one side. The real question is whether he's right that an executor removal application should be determined on the basis of meeting a threshold test that's not a balance of probabilities test on the allegations that are being made against the executors. And he's quite clear, the Chief Master. He says, you don't need to use a Part 7 claim. You should be using, in fact, he was critical, wasn't he, of the claimant for using a Part 7 procedure. You just got to use a Part 8 claim. So there's going to be exchange of evidence, but there's not going to be pleadings. There may well be no disclosure. He didn't think any cross-examination was required, even on allegations that did seem to me to be tantamount to allegations of bad faith. And I think he accepted they were allegations of bad faith in Schumacher, but said there didn't need to be cross-examination because those allegations are denied. And then, as you say, he has built up this test, which seems to have been applied in other first instance decisions, that if you get over a threshold, which seems to be the good arguable case threshold, it looks like a summary judgment threshold, then that's enough, and that warrants the removal of the executors. And I think in Longman, he said, if the beneficiaries are able to make out complaints that warrant further investigation, then that's itself sufficient to justify their removal. So certainly it seems to me that these authorities place the bar very low indeed in relation to questions of conflict or breach of duty or misconduct. And it's difficult, I mean, we can come on to talk about this, but it's difficult to see how an executor is supposed to meet a claim like this when effectively the court is saying, if there's smoke here, then I don't need to determine if there's fire because that's enough. And it's a far cry from the test as set out in Letterstedt, certainly in relation to misconduct claims.
Yeah.
So, yeah.
Sorry.
No, that's fine. I was going to ask about costs, which might be a good point to hand back to Charlotte, because we can talk about what you actually do as an executor in these circumstances. But I think to know how brave you're going to be, you've got to know what the cost risk are in a like this. So Charlotte, why don't you just talk us through that?
Sure. Thank you.
The cost slide, sorry. I think we've sort of gone over procedure very briefly. So if we can skip past procedure, part A, obviously, and then move on to costs.
Sounds good. So applications to remove or replace executors are subject to the usual cost rules under CPR Rule 44.2. The general rule being that costs follow the event, so the unsuccessful party pays the successful party's costs. However, costs in executor removal applications also fall under Part 46 of the CPR. And this covers costs in special cases. Rule 46.3 applies where a person is or has been party to any proceedings in the capacity of personal representative. And that person is entitled to be paid the costs of those proceedings insofar as they are not recovered from or paid by any other person out of the estate or the relevant trust fund, and those costs will be assessed on the indemnity basis. Practice Direction 46 also provides that executors are entitled to an indemnity out of the estate for costs properly incurred. So that's the very important point that all executors are going to have to remember when they decide whether to defend or be neutral in proceedings. And whether costs were properly incurred depends on all the circumstances of the case, including whether the personal representative acted in the interests of the estate or acted unreasonably in bringing or defending or in the conduct of their proceedings. So there have been a number of recent cases in which the court has been critical of an executor's conduct in relation to removal proceedings and has deprived the executor of their indemnity. One such case is Griffin versus Higgs. This was, the cost judgment was handed down in 2017, and it then went on to appeal in 2018. It was an appeal against a cost order which prevented the removed executors of trust from being entitled to their indemnity in respect to their costs of the claim. So the original removal application was brought by one of the beneficiaries of the estate due to investigations which were required into a number of lifetime transfers made by the deceased at a time when she was suffering dementia and with the assistance of the executors. So both first instance and appeal, no surprises, the court agreed that the resulting conflict of interest meant that the executors couldn't conduct the investigations themselves and should be removed. The executors here were two solicitors and an accountant, and they initially resisted the removal application. But just before the hearing, subsequently abandoned their defence and took a neutral stance. I think it was 8 days before the hearing. And they thereafter left it to the remaining beneficiaries to defend the claim. Deputy Master Linwood, hearing the original application, provided a cost judgment which split liability into two periods. So the period up to the date of the hearing when the executors continued to actively oppose their removal was the first period. And the second was following the start of the hearing when the executors decided to take a neutral stance. And in applying the general rules on costs and considering whether the executor's costs had been properly incurred, in respect of the period up to the hearing, the Deputy Master held that the executors hadn't acted reasonably in opposing their removal in light of the conflicts of interests being plain and obvious. And he therefore refused the executors the indemnity on the basis that they should have adopted a neutral stance from the commencement of proceedings. The executors, together with the beneficiary defendants, were also jointly liable to pay the costs of the claimant beneficiary during the period up to the hearing. And as for the period following the start of the hearing, so the second period, the Deputy Master held that the executors were still not entitled to an indemnity because the adoption of a neutral position left them present at trial and expecting the estate to pay for the costs, he said, of a late change of position would have a detrimental financial consequence for beneficiaries. However, the beneficiary defendants were ordered to pay the claimant's costs and the executor's costs for this second period, as it was held that the executors could have adopted a neutral position much earlier if the beneficiary defendants had agreed to it. And at appeal, the High Court agreed that the executors had acted unreasonably in defending the claim initially, and that as a result, they should pay the claimant's costs for the period during which they defended the claim, and were not entitled to their indemnity. However, the appeal court said that after the executors had changed their position, the deputy master was wrong to deprive them of their indemnity out of the estate. It was held that costs continued to be incurred after resistance to the application was abandoned by the executors due to the defence mounted by the beneficiary defendants, and the executors shouldn't be deprived of the indemnity due to this. And I guess this case demonstrates that personal representatives, especially those with little or no beneficial interest in the estate in question, must very carefully assess whether they want to be actively involved in the litigation due to the potential personal cost implications of that. And in order to avoid being at risk of personal costs, executors should remain neutral and allow the beneficiaries of the will or next of kin to pursue the litigation. Their only obligations in the proceedings really should be to provide information and preserve the estate. This feeds us, I'm conscious of time, but just very quickly, this feeds us into the final how-to section of the seminar. There are a number of practical tips and potential traps to consider in this area, which we've already considered some of them, which vary depending on whether you're seeking to remove an executor or facing a removal application. So to take the first of these, how do you go about removing an executor? If a beneficiary is considering removing an executor, careful consideration should perhaps go into the pre-action correspondence, shouldn't it?
Yes, absolutely. I just noticed James Lister asked a question, which is what about the reliance on the Kahn and Crossland type of case, where the beneficiaries just want to get the executor out, but without necessarily there being allegations or findings of wrongdoing, which is absolutely right. And I think where we get to is probably these claims break down into two camps, don't they? Or possibly three. The first is where you actually have some allegations of conflict or wrongdoing to make against the executors or trustees. Category two is where you think they've been a bit rubbish, but it doesn't necessarily amount to a breach of duty or a conflict that would disentitle them from acting.
Human infirmity cases.
Say that again, Rosie?
Human infirmity cases.
Human infirmity cases, yeah, exactly. A human infirmity case based on the mode of administration of the trust. So their administration of the estate or the trust has been so rubbish in some specific way that you have reasonably lost trust and confidence in their ability to act. And then what you might call pure friction or hostility cases, where you just hate them, but you can't really explain why in a coherent manner. I think it's right to say that if you're in the pure friction or hostility category, then you will be faced with dictum number 3 from Lord Blackburn in any application for removal. And so what you're going to try to do is bring yourself into what you might call a mode of administration category, what I've called before a breakdown plus. So there's a breakdown in the relationship, but it's based on something the executors or trustees have done, or then a case of actual allegations of misconduct or conflict that at least meet the Master Marsh test of something further to investigate. Yeah.
I think this can be really interesting when you have a claimant who is one of a class of discretionary objects, say, and they fall into what Andrew calls the third camp, or even perhaps the second camp, where they just hate the executor And the response to that could well be, well, looking at the judgments recently, you're looking at the class of beneficiaries as a whole. You're not really looking at whether one particular discretionary object has a complaint or an animus against the executor. That's just not going to be good enough. So as you say, you have to try as a claimant in those circumstances, I think, to broaden it out and to make it less about you and more about the benefits of the beneficiaries as a whole class, I think.
Mm. Yeah, I agree with that. And I mean, given the low bar that's been set by Long and Rodman and Schumacher and Clark, what you're going to be looking to do if you're acting for the claimant is to set up circumstances in which it can be said that there is some wrongdoing on the part of the trustee or the executors, which disentitles them from acting, because you don't actually have to prove that anymore. You just have to allege it. And as long as it's
horrible letters, Andrew.
Well, you create a lot of smoke, don't you? And it almost becomes inevitable that the allegations lead to the removal, because the allegations themselves make it untenable for the trustees or the executors to continue in office, which is, I have to say, from a sort of policy perspective, not ideal, because it will be encouraging litigants to manufacture problems, which then lead to a conclusion that the executors must be removed, in circumstances where, you know, if those allegations were tested properly at trial, they may be shown to be unjustified.
Which professional executor especially would want to be put through that, or even to get that far? I suppose that leads us on to the next slide, which is, you know, how do you respond to a claim like this if you're a lay executor, a professional executor? Should you ever cling to office, or should you always just say, okay, it's just not worth it, I'm just going to step down because I don't want to put myself at cost risk, I don't want to be involved in a contested hearing, even if it's not a full trial?
Rose,
well,
I've intruded upon the panel again, to sort of ring a bell in terms of time, also to say that I'm going to seek out Elizabeth Squires hopefully after this, because I have the exact scenario she's described, so I'm going to gain you some time by taking that question away. But I did have another question for you, which relates to costs and neutrality, and the situation that I often encounter is where the executor may not want to cling to office, is quite happy to go, but does want to have some say over their replacement. And I found it quite alarming that even doing that seems to cross, you know, through the threshold of neutrality. I wondered about your thoughts on that very quickly.
I suppose it depends on who is being proposed as the replacement, doesn't it? But it always seems to me that trustees or executors can insist on proper people being appointed in their place. So if you're getting a suggestion from a beneficiary of a professional where there's no conflict hinted at, then probably you'd be wise to assent to that, because one professional is as good as another, some might think.
Really?
Well, don't tell the general public. But if the suggestion, Jess, is for a family member or something like that, where there's a real concern about what's going to happen to the administration, I think that's where you're going to be more justified in standing your ground, probably. I don't know what you think, Rose.
I think that's what happened, if I recall correctly, in Long and Rodman, isn't it?
Exactly.
Where I think the claimant, the sisters, has said, I think nearly up until trial, well, we should replace, or one of us should replace, I can't remember. And it was only, you know, just when it came to trial that they said, okay, well, you know, we can have a proper person, a professional. I think there had been opposition by the executor up until that point. And I think there was argument in the cost judgment in Long and Rodman about the fact that almost that the claim had totally changed its quality when they said, okay, a professional can be appointed. Because I think, as Andrew says, you know, if you've got concerns about who you're handing over the trust estate to, then, you know, it might be legitimate to write a letter saying, well, what about this appropriately qualified professional?
Yeah, I think it's more of a concern
let's have your tips. I'm very concerned that we shouldn't leave without them.
Well, Rose, do you want to do tips for the claimant, and I'll do tips for the defendant, the poor executors?
Well, I suppose tips for the claimant is what we've been discussing. You know, when you're writing your letter of claim, you want to be thinking about the test looking at the estate as a whole, not in the heretical sense of looking at it as a sort of a separate legal entity, as I think upsets Andrew, but looking at the beneficiaries as a whole and saying, you know, would the continuation in office of these executors be detrimental to the interests of the beneficiaries? And you are really looking at instances of that happening. You know, have there been, if you're looking at category 1, have there been any breaches of duty? Or is it the case that the relationship is broken down and that's impeding the administration? You know, is there some communication problem? Has it become impossible for there to be communication between the executors and the beneficiaries? And you really just want to be setting that out. And perhaps I really hesitate to encourage some kind of manufactured relationship breakdown, because, you know, people always get criticised for that in correspondence. You know, you're obviously trying to manufacture this relationship breakdown by writing us horrible letters, but you are going to want to keep an eye on how the executor is responding to your correspondence and whether they're dealing with it in an appropriate and neutral way. Do you agree? Tips for the defendants?
Yeah, that sounds good to me. But if you're for the poor executors, then I think a couple of tips are: first, it's great if you can divide and conquer the beneficial class. Because if you have a unanimous beneficial class against you, then you really are in difficulty. But if you can get a branch of the family supporting your continuation in office, then you are in a much stronger position. And the cases go so far as to suggest that it might be inappropriate for you to be removed in those circumstances. Make sure you keep the administration going so that you're shown to be very good executors objectively, and so there is no objective complaint that the claimant can have about how the administration is being impeded. Frame the claim as a breakdown in relations, so get yourself into the mere friction or hostility dictum. Avoid the other two. If you get into that one, then you will survive. And I mean, Lewin says that if you're faced with a misconduct allegation, you should send a Part 36 letter denying the allegations but offering to resign. I don't think it's really a Part 36 letter. I think it's just maybe a WP save as to cost letter. But certainly I think that's good advice. Based on the Schumacher and Clark threshold, you should be getting out of there if there are allegations of misconduct against you, I would have thought. So the Lewin approach is a sensible one. And then dictate terms. Make sure you get your indemnity. Make sure you get your replacement, who you choose. Anything else you can do to make the claimant's life a misery before you resign would be sensible.
Give them lots of lovely and detailed accounts so they can't complain about that. What else can you do, really?
Yeah, I mean,
don't get drawn into writing them petty responses.
No, don't lose your temper. That's a very good one. I mean, I certainly think that given where we are on the authorities, most executors are going to be resigning before we get to the stage of a contested hearing. But you just have to try and manage the process as you go along.
Well, thank you very much to all three of you. That's been a great session, and yeah, looks like Elizabeth and I have some catching up to do. I hope that we'll see some of you for the networking, which is on the other Zoom link that hopefully you received in an email from me. So I look forward to seeing you on the other side. Thank you, everyone.
Thanks very much.
Bye.